Okay, so let's begin. Grounds for divorce. Different laws govern people belonging to different religions. HMA governs divorce among Hindus. Parsi Marriage and Divorce Act governs divorce among Parsis. Indian Divorce Act governs divorce among Christians. Muslims do not have a codified law. They are governed by their religious text. Decree of court is required for dissolution of marriage, but Muslims are an exception. In Muslim law, husband enjoys special privilege. He can divorce his wife at his will without citing any reason. Earlier, Muslim wife had no corresponding right of divorce. It is only after passing of Dissolution of Muslim Marriage Act 1939 that wife has been conferred right to obtain divorce. So, decree has to be obtained from the court for dissolution of marriage. This is the general rule, but it is subject to an exception, that is of Muslims, under which husbands have special privilege that without citing any reason as per his wish and whenever he wants to, he can divorce his wife. And wife had no corresponding right of divorce until 1939 Act, and it only provided the right to the wife to seek divorce. तो पहले क्या था, सिर्फ हस्बैंड ही क्लेम कर सकता था, चाहे वाइफ के साथ जो भी एट्रोसिटीज़ हो रही हों in the Muslim marriage, but she was not having any right to claim divorce. HMA governs Hindus in matters of marriage and divorce. Both husband and wife are entitled to file petition for dissolution. This petition can be filed on grounds of adultery, cruelty, desertion, unsoundness of mind, and so on. So basically, in depth, you will be dealing with all these grounds when you study proper HMA. But here, not much depth is required, so you can only understand and learn the grounds of divorce. Adultery, that is, as I explained you in the last video, intercourse outside wedlock. Cruelty, such a nature that it is not possible to live for further more years with the person, that can be physical or mental. Desertion also, I told you, unsoundness also, I think, is clear, right? Paris as Parsis and Christians recognize adultery, cruelty, desertion, unsoundness as grounds. Indian Divorce Act governs Christians, and in this, husband can file petition of divorce only on ground of adultery, whereas wife can file petition on the above mentioned grounds. If husband is guilty of rape or sodomy or bestiality, then wife can file petition for divorce. This remedy is available to Hindu, Parsi and Christian wife. So for the husbands claiming divorce in Christianity, there is only one ground, that is adultery, which is done by wife. If husband is claiming divorce, of course that means the other party is at fault, right? That means the other person may have done something because of which this aggrieved party is filing that now I can no longer live with this spouse, right? So the wife has committed adultery, and wife can file petition on the above grounds like adultery, cruelty, desertion and unsoundness, all four. If husband is guilty of rape, sodomy or bestiality, so bestiality is rape with an animal, okay, this remedy is also available to other Hindu and Parsi's wife. Then matrimonial rights and obligations. I have been using this term marital obligations, which are conferred upon both the parties, husband and wife, post their marriage. So now we will discuss what are those marital obligations, right? So there is some responsibility that comes as soon as a person gets married. Yes, the woman has to move to the matrimonial house or the house of her husband, and she has to perform the basic household chores which are required over there. So that is the, the least expectation which is done from the wife, that she will now be handling over the chores of the house, right? And husband has to maintain his wife, take care of her needs, of her necessities, right? And also, if there is a children born out of the wedlock, then both the parents have the responsibility to look after and to nurture that child to whom they have given birth. Yes, so that includes maintenance and inheritance, which in inheritance you can, and actually in both maintenance and inheritance, it is of both the wife and the child by the husband. Okay, so conjugal rights. So whatever we are gonna discuss now, a brief picture of it already. It was explained in the last videos. Okay, so, marriage confers conjugal rights. These are rights and privileges arising from marital relation, especially the mutual rights of companionship, aid, that is help, sexual relation. The basis of this right is consortium, that is union, association or alliance, or a legal right to have comradeship and support with the other, right? So the basic expectation is that this person will support me throughout my life. He will be standing through thick and thin, he or she, right? So that is the conjugal rights. That is also uh, including the right of cohabitation. That's why when we say RCR, that is restitution of conjugal rights, तो उसमें basically क्या होता था, that the court orders the spouse who has left without giving any explanation to return back to the house and start living again, and not deprive the spouse of the basic right which he has or she has, because he is part or he is still in that wedlock. Okay, so that is cohabitation, means the state or act of dwelling together in same place with one another. The living together is supposed to be the quintessence sexual relationship. It means emotional and physical intimate relation, which includes common living place, that is matrimonial home, where the couple resides post their marriage. So it is an essential part that why the marriage is performed, so that those two can live together and lead a life. So the basic thing, the first thing that comes is that they should live together in a place. And if they are not living together, then there is no, you know that would, you can say, defeat the purpose. And if there is a reasonable cause that because of their jobs they have to living in a long distance relationship, that is okay. But if there is no sufficient cause and they are not coming together, they're not ready to live together, so that is the violation of marital right of the other spouse. Then maintenance. A man takes on an obligation to support his wife out of his earnings or other income in a style commensurate with his total income. Okay, so in a style means the standard of living. Commensurate means corresponding to the total income or his earnings, of course. If he earns 50,000, okay, and the wife is claiming that my expenses for a month are 1 lakh, so that is not corresponding to the total income. So that is not expected that he will maintain to that standard, or he should maintain, because she is his wife. Okay, so the husband has the obligation, but that has to be corresponding or proportionate to the earnings. This remains in force for duration of marriage, even if the wife has an adequate income of her own. Okay, so that means this husband has to support wife, that is of course till the time marriage persists or they are in that wedlock. It can also be for some time longer, but even if the wife has an adequate income of her own, that means even if nowadays you can see that women are also earning, so even if the wife is an earning member of the family, still the gender roles which are prescribed as per the society, that is women will be handling the house, and how she will handle it, who will give the money for that, the man. So man has to work outside for maintaining his family, right? So even if she is an earning member, but as per the prescribed gender roles, I am telling you, no offense to any gender. Earlier there used to be division of work, Husband used to earn livelihood and duty was to maintain and protect wife, and wife's duty was to live under the roof and protect the husband. Under Hindu law, wife has an absolute right to claim maintenance. Her right to maintenance is given in Hindu Adoptions and Maintenance Act. In accessing the amount, court takes into account various factors like financial position and liabilities of the husband. Liabilities of the husband can include that who all are other members of the family who are dependent upon the husband for their maintenance, who are not able to maintain themselves and they cannot earn at this age, and so they are dependent on the husband. Okay, and he has to take care of those people also. That can include his old age parents, his children. Okay, and now he will be at the responsibility again to maintain them also. So a portion of his income has to go for them, right? The whole of his income he cannot contribute for maintenance to his wife, and a portion of that also has to be kept for his own expenses, right? So पत्नी का तो दे दे रहा है, बट अपना कहाँ, अपना लेने कहाँ जाएगा? So that all has also to be taken care. And liabilities can also include if there is any loan from a bank which is due इन द हस्बैंड्स नेम, कोई उसने लोन ले रखा है और उसके इंस्टॉलमेंट्स भी पे करने हैं. सो दैट ऑल हैज़ टू बी कंसिडर्ड. एंड ऑफ कोर्स द अर्निंग्स, कि कितनी अर्निंग्स हैं, जिसमें से कितना पोर्शन किधर किधर जा रहा है, that all has to be taken into consideration. And to maintain the basic standard of living of the wife, according to that monthly installments of maintenance can be decided by the court. And there is no such parallel right, means husband cannot claim such right of maintenance from the wife. But nowadays in very rare cases it happens that husband can also claim maintenance if he is not earning and the wife is earning and she is able to maintain the husband. But if any matrimonial dispute is brought before the court, then HMA provides that either husband or wife who has insufficient means, meaning thereby that he is not able to maintain himself or herself, okay, to lead a better life, or he is not having money, he is not having food, so whatever he is having, that is not enough, and he can claim maintenance pendent light. Pendent light means when the suit is pending or when the proceedings are still going on in a court of law. तो उसके पास इतने भी पैसे नहीं है कि वो अपने travel expenses दे सके from the place of living to the court and the lawyer fees. Okay, so that can also be asked, or permanent alimony, that is maintenance when the case is finally disposed of. Okay, and these are different from litigation expenses. Suppose wife has filed a case or husband had filed the case for divorce in a different city where the wife is a new, और वाइफ डज नॉट नो, क्योंकि हस्बैंड का वहाँ ट्रांसफ़र हो गया था तो उसने अपने उसी जगह पे फाइल कर दिया. बट वाइफ इज़ न्यू टू दैट प्लेस, सो द एक्सपेंसेस ऑफ लिविंग देयर, द ट्रैवल कॉस्ट, ऑल दैट कैन बी टेकन. And she's not having those expenses, right? कहाँ से लाए वो, she's not earning, so that can be claimed from the husband. That is under HMA. And this absolute right of maintenance was under HAMA, Hindu Adoption and Maintenance Act. Don't get confused. There is also one. These are the civil laws under which the wife can claim maintenance. But if you go on to the criminal side, then section 125 of CRPC, also the wife can claim a code of criminal procedure, which is now actually changed to BNSS, right? The new criminal law. Then she can claim maintenance under that also. Fine. And in CRPC there is not only wife, there are parents, children and wife who are not able to maintain themselves. In fixing the quantum of permanent alimony, court will determine what is just. Just means what is the amount that can be reasonable. that can be a better off and will do justice to both the parties, to the wife, to the husband also, that husband की जो भी अर्निंग्स है उसके करस्पॉन्डिंग अमाउंट है, कुछ बहुत ज़्यादा नहीं दे दिया जो देने में हस्बैंड की हालत ख़राब हो जाए और ऐसी सिचुएशन में पहुंच जाए दैट ही इज़ नॉट एबल टू मेंटेन हिमसेल्फ। हमें उसको गरीब बनाकर किसी और को हेल्प नहीं करना है। We don't have to do injustice to one party to do justice with the other, right? This is not the concept. So court has to determine, seeing all the surrounding circumstances of the case as a whole, and it has to decide that what amount will be reasonable, bearing in mind the ability of husband to pay. What is the earning of the husband, what amount from his salary he can pay. Considering these above factors, financial position and liabilities, right? And the wife's own assets and conduct of parties, that means what all property the wife has, so she can incur income from that property. She has a house in her name. If she lives in one room and gives the other room or other portion, other floor of the house on rent, she can very well incur income from that, right? And even if she sells that house, then also there will be a gain. Property will never let you at loss, okay? Whenever you sell it after few years, the price is only and only gonna increase, isn't it? So those assets will be taken. If she is earning, okay, like बहुत कम इनकम है बट शी इज़ अर्निंग, सो अकॉर्डिंग टू करस्पॉन्डिंग अमाउंट it can be given that okay, you are granted this amount more including your salary, now you are able to maintain yourself and now not anything more will be claimed or allowed to claim from the husband. So that all has to be taken. This is what I mean when I say taking all the surrounding circumstances of the case as a whole. Okay, whole means this whole. Fine. The order will remain in force as long as wife remains chaste and unmarried. Chaste means a sort of pure and unmarried. So as soon as she does not remarry, she is the responsibility of that man. As soon as she remarries, so now whoever is the new husband, he has the obligation to maintain his wife. तो वो उस कैटेगरी में जाकर एक वाइफ का स्टेटस ले लेती है with relation to another man. So now the earlier husband or the ex-husband to be precise, he is not at an obligation to maintain her. Okay, so two people cannot maintain one person, right? So दोनों की obligation नहीं लगा सकते हम. So as soon as she remarries, responsibility shifts. So you can say the duration of force of the maintenance order is till the time the wife remarries. The Parsi Marriage and Divorce Act recognizes right of husband and wife to claim maintenance pendente light and permanent. Parameter for granting is same as in Hindus. And what is the parameter in Hindus? Again and again I am saying financial position and liabilities of the husband. Okay, and also wife own assets, ability of husband to pay and conduct of parties. Under the Muslim law, Muslim Women Protection of Rights on Divorce Act protects right of Muslim women who have been divorced by or obtained divorce from their husbands. So who have been divorced by their husbands or who have by the 1939 Act claimed and obtained divorce from their husband. Okay, that is the difference. Failure on part of husband to pay maintenance entitles her to obtain divorce from the husband. If the husband is not maintaining his wife, he is not giving proper money for her to get the basic necessities, clothes, food, 2 square meals a day, she is not feeling well, and if she is asking for medicines, husband is not giving her money for that, so that is not maintaining the wife, and in such a situation again she can claim divorce from the husband. The Indian Divorce Act governs maintenance rights of a Christian wife. This act does not apply to any of Hindus, Muslims, and Parsis. Why is it is written? Because it says Indian, no? So you may have a misconception that all those Indian people पे apply करेगा. नहीं. So see the year in which it was passed, right? During the British era. So whatever that time was, it was Indian. But this applies only to Christians and not to the other religions. The provisions are same as under the Parsi law and same considerations are applied in granting maintenance. Now we come on to inheritance right. When one person, now what is inheritance? When you inherit something, you get something from your ancestors, right? Or from your previous generations. That is that you have inherited this property. So when one person dies without making a will, that means वसीहत जिसको बोलते हैं, उन्होंने कोई ऐसा डॉक्यूमेंट अपने लॉयर से नहीं बनवाया था जिस पे वो साइन करके गए, and the document would have contained the information regarding what all property he has and in what way that property has to be given and to whom. This whom includes the family members or some outsider who may have taken care of that person very dearly. ठीक है, बहुत मेहनत करके उसने जो डिसीज्ड पर्सन है उसकी ध्यान रखा था, तो वो उससे इम्प्रेस होकर उसको दे गए, बिकॉज जब उनको ज़रूरत थी तब उनका कोई फैमिली मेम्बर उनका ख्याल रखने के लिए पास में नहीं आया था, तो जिसने उनका ख्याल रखा उसको वोट देकर चले गए. दैट कैन बी अ सिचुएशन, राइट? सो दिस इज़ डिसीज्ड. I will be using this term so you know what is the spelling and what it means. It means the recently died person, right? So when person dies without making a will, then will contains information regarding property devolve on whom and in what proportion, right? But if there is no will, then what? The property passes on under the law of succession. ठीक है. सो वट एवर द लॉ ऑफ सक्सेशन कोडिफाइड फॉर्म में है हमारे पास, फिर हमको उस हिसाब से देखना पड़ेगा. अगर विल होती तो जस्ट जो विल में लिखा है वो हम कर देते. दैट इज़ द पर्पस ऑफ मेकिंग अ विल. ओके. When two persons get married, they get mutual rights of inheritance. That means husband will inherit what all belongs to the wife and wife will inherit what all belongs to the husband. There is one exception which I told you in the previous class. I hope you remember. If you don't, check out the previous video. Different laws of succession govern persons belonging to different religions. That is personal law, of course. So different person, different religion, different rule of succession. Under undivided Hindu family, that is also known as joint Hindu family, because earlier there was only the joint setup, right? That means joint setup means there is a father, he has 3 sons, and these 3 sons also can have more than one son and a daughter. Okay, so now she will be married and she will move to another family, she will be a part of that joint Hindu family. But just for an example, so these all are living together in one house, that is Hindu undivided family or joint Hindu family. Okay, and they may also have their wives, right? So they are also a part of the family. If a male or female dies without making a will, then property is distributed as per rules of succession in Hindu Succession Act. So for succession among Hindus, we have HSA. Under the act, both husband and wife are included in the category of most preferred heirs. Most preferred heirs means class 1 heirs. So we have under Hindu Succession Act, we have certain classes of people. Okay, class 1, class 2, class 3 and class 4. This is the most preferred class, means सबसे पहले इन्हीं लोगों को दिया जाएगा. If there is no one in class 1, then we will move to class 2. If no one in class 2, then to class 3 and then to class 4. This is how it goes. Okay. and all members, if there are more than one members belonging to class 1 here, then all of them will simultaneously get a share. I'm not going into much deep, but just to explain you that what this term most preferred heir means. The class 1 heirs, okay, the husband and the wife, they are included in that category. That means first of all they will only be the persons to inherit each other's property. Both can make a will of his or her separate properties and give them to anyone. So will is the choice of the deceased, you cannot question that, and you have to follow the will if it is in possession, if it is made. So they can make will according to their choice of what property they want to give to whom and what proportion. Okay, if they want to give it to more than one, then in what proportion that has to be given post their death. So that will be followed. Why will is made? Because when the property will be given to those people, he will not be alive to see that or to administer that, and or to see that it is done properly. So he writes that in a will. रिटन फॉर्म में होना इसलिए भी ज़रूरी है क्योंकि एग्जीक्यूशन में इजी हो जाता है. ओरल बोल के गए, अरे उन्होंने तो ये बोला था, सो दैट कैन चेंज. ईच पर्सन कैन चेंज वॉट ही हैड सेड ओरली, what the deceased had said orally according to his favor. उन्होंने मुझे ज़्यादा देने के लिए बोला था मेरे से, ठीक है, और अगला बोलेगा नहीं मुझे ज़्यादा देने के लिए मुझसे बोला था क्योंकि मैंने उनका ज़्यादा ध्यान रखा. सो देर कैन बी अ कॉन्ट्रोवर्सी, एंड सिंस दैट पर्सन हैज़ डाइड यू कैन नॉट प्रूव दैट हु इज़ सेइंग करेक्ट. Yes, so it is better that it is in written form for execution, and that has to be followed. But ancestral property has to be disposed of according to HSA. So if there is a separate property, now again the point of difference between these two terms, separate property and ancestral property. If suppose the joint family that I drew earlier, that whole chart, suppose they have a property P, okay, and one of the son has his separate property. That means out of his earnings he had saved something and he purchased a piece of land, okay, out of his own income. So that is his separate property that only belongs to him and him alone. And this property P, which is of the whole family, that whole chart that I drew, okay, that belongs to the whole family, all the sons, daughters, all the wives, okay. It belongs to everybody, though the wives of sons will not be included as the owner of this property, but they can claim a share in the property when their husbands die. अगर ये सारा एक्सप्लेनेशन कौन कैसे इनहेरिट कर रहा है ये अभी समझ में नहीं आ रहा तो कोई दिक्कत नहीं है, ठीक है, बिकॉज यू आर नॉट रिक्वायर्ड टू स्टडी ऑल दैट हेयर, बट जस्ट फॉर योर लिटिल ब्रीफ नॉलेज and to explain you these terms I am telling, otherwise it is not actually required. So please don't take pressure of searching them and wasting your time to understand. It's not a complex thing. Separate property means either the person has purchased it or he has obtained it by a gift. Only and only he is the owner. Okay, तभी हम उसको अलग कह रहे हैं. And ancestral means it is passed off by generations. It belongs to the ancestors. That is the joint family of every son. Okay, and this ancestral property also means that on this whole plot, on this whole plot, each of the son would have a share. Suppose this S1 has only this share, S2 has this share, S3 has this, S4 has this. So इतना ही पोर्शन है उनका. And if someone is born, तो प्रॉपर्टी तो उतनी ही रहेगी ना. मेरी बड़ी हो गई है because I'm drawing an hypothetical picture, but property will remain the same. Property नहीं बढ़ी है, but number of people who are the owners of that property, that will increase. So now their portion will decrease, right? They were claiming 1/4 earlier, now there are 7 members, so each son will be claiming 1/7. The proportion has decreased, right? That is the meaning and the difference between separate property and ancestral property. But in the case of separate property, that whole will belong to the son, even if people are born or die in that joint Hindu family. Okay, so in separate property, they can make a will, and that will be disposed of as per the will they have made. And the ancestral property का succession हिंदू succession act से ही होगा. ठीक, कि कौन सा शेयर किसको मिलेगा, that all will be decided from there. Under Muslim law, in the case of death of wife, share of husband is 1/4 of property when there is a son or child. But when there is no child, then husband will get half of estate of wife. That means there will be two pictures over here. In Muslim law, this husband, this wife, and a child. Okay, so if there is a child, then he will also be inheriting some property, right? So in that case, husband gets 1/4. But if there is no child, that means no one to inherit property apart from him, so he will get only half of it. हाफ किसके पास रहेगी, इसके पास. ठीक, वो अपनी भी तो कुछ अपने पास रखेगी ना, सो इसके पास रहेगी. एंड हाफ विल बी गिवन टू हस्बैंड and there is no child. In case of death of husband, share of wife is 1/8 when there are children, but if there are no children, then her share increases to 1/4. Under Muslim law, there is a restriction that Muslim cannot dispose of by a will more than 1/3 of his property. That means if the property is around 100 square meter, for suppose 100 square meter property is owned by a Muslim man, but and he makes a will of that, then will cannot be made of 1/3 of his property. That means 1/3, what would be the 1/3 of this? Better you take it 300 square meter. Okay, 1/3 would be 100 square meter, isn't it? So he cannot dispose of the property more than 100 square meter if he is making a will of it. तो सोचो 200 square meter जो बची उसका क्या हुआ? That may go to the government because there are no heirs of it. It is disposing of to the heirs only, no, to the legal heirs only of the man when he dies by will. But वो restriction की वजह से now 200 cannot be sold off, that cannot be disposed of to anybody. Yes, that can go to the government in the principle of escheat. Okay, again, no need to go in deep. Or that can also be sold off to the other person so that you can gain benefit of it. You very well know that it cannot be pass on by a will, so you sell it off. Fine. So, and also one more thing, in Muslims there is a proportion of 1:2. That is, one adult male is equal to two female witnesses. Sorry, two females. What does this mean? Suppose if there is a requirement of two witnesses, and in those two witnesses we have one male and one male. ठीक है, one male plus one male. But if one of the male is not available and females are there, so you will not say that okay हम one female को बैठा देते हैं उनकी जगह पर. नहीं, तब आपको दो फीमेल्स बैठानी होंगी, and two females will be equivalent to one adult male sitting over there. Fine. So that is the concept. That's why over here if you see this 1/8 and 1/4 is coming in comparison to the above where this proportion was 1/4 and 1/2 for a man, right? Fine. Matrimonial property. Property and rights received at or about the time of marriage belongs jointly to husband and wife. Matrimonial property means property which are received before, at, or after, just after the marriage. That's it. That is about the time of marriage. Okay, at तो समझ में आ गया, when the marriage is going on. About means before and after. ठीक है, whatever gifts they have received, that belongs jointly to both of them. Generally also whatever is of husband, that belongs equally and jointly to the wife. They are considered as one unit, right? So whatever belongs to one person, that is the joint property of the other as well. But there are certain properties belonging exclusively to one of them. For example, Stridhan. I told you this. Any gifts given to wife by her parents in laws exclusively belongs to her, and she can deal with it the way she wants. It exclusively belongs to the wife only. Husband has no claim over it. Concept of dower under Muslim law is another example which belongs exclusively to the wife. Dower is a sum of money or property that wife is entitled to receive from the husband in consideration of marriage. In consideration of marriage means for acceptance by the wife to marry the man. He gives certain property or money that okay, I will take care of you, or I am gifting you this amount of money in exchange of the duties that you have to perform as a wife. Okay, so this is one part or one example of consideration in Muslim marriage. There was another example of consideration in Muslim marriage in the case of divorce, which we did in this video or in the last video. I hope you remember. If you don't, you need to check out. In fact, it would be more correct to say that dower is an obligation imposed on the husband as a mark of respect for the wife. Okay, so as a token of respect, there is a duty of husband to prescribe the amount of dower, and that is mentioned in the nikah document, that this amount of dower is fixed and husband has to pay this amount to the wife. Okay. Prohibition of Child Marriage Act. Minor is a person who has not completed age of 18 years. So that is a child, isn't it? And child cannot marry because why this age is set even for voting rights, because that is considered to be a sane age criteria passing which the person gets the ability, or his mind develops to a stage where he is capable of taking his own decisions, considering what will be bad or what will be good, and what will be the consequences of his own act, right? What is wrong, what is right, that is also he can differentiate fairly, roughly. So it is assumed that he has gained majority. Fine. So with respect to age of marriage, HMA, Parsi Marriage Divorce, Christian Marriage Act, they also prescribe age of 18 years for girls, 21 year for boys. In India, child marriage which takes place of a girl less than 18 years and less than 21 years in case of boys. So if the majority age or the age of marriage for a male and female is such, then child marriage का मतलब क्या हुआ कि उस एज के कम की शादी हो रही है, right? So in India, child marriages earlier were prevalent. I can say that they are still prevalent in some remote villages. They know what are the laws and it is prohibited, it is abolished, but still it is happening. It's just that it is not reported, or it does not come into notice, or even if it comes into notice, we let it go कि अरे personal matter है, we have so many problems in our own lives, हम उसको झेल लें वही काफ़ी है, दूसरे के फटे में हाथ क्यों डालें, right? So that is the thing. Anyways, when Hindu Marriage Act was drafted, it did not affect the validity of child marriages. That means a child marriage will remain valid. Okay, so the child marriage which was conducted before or at the time of commencement or at the time of coming into force of this HMA, the validity of those marriages which were already done, that was not affected. That means it continued to be valid even after the passing of HMA, which prescribed the age limit. Okay. Only some minor penalties, that is 15 days simple imprisonment. मतलब कुछ काम नहीं करना. Rigorous imprisonment means you have to perform labor. You have to live in jail also. You have to work there also. जैसे bricks उठाना हो for construction, या कपड़े धोने हो, या whatever works for rehabilitation after you are set free from the prison. So that is rigorous. But here 15 days simple imprisonment and fine extending to 1000 rupees were imposed, else large number of marriages would fall under the category of void or voidable. Because पहले तो होती ही child marriage थी ना, तो when the act was drafted or when it was made, it came into force, तब तक जो marriages already हो चुकी थी उसकी validity को इसने कोई असर नहीं किया. क्यों अगर ये बोलता कि आज से पहले हुई जितनी भी मैरिजेस हैं वो सारी हम वॉइड मानते हैं, दैट मीन्स फ्रॉम द डेट व्हेन मैरिज वॉज परफॉर्म्ड वी विल कंसिडर दैट इट इज़ नॉट एग्जिस्टिंग. सो बहुत सारी मैरिजेस वॉइड या वॉइडेबल हो जाती. वॉइडेबल ऑल्सो यू नो वॉट इट इज़. सो टू नॉट रिजल्ट इनटू सच अ chaos, क्योंकि तब और ज़्यादा पेंडिंग केसेस और यू नो देर वुड बी अ रक्कस इन द सोसाइटी, उसको प्रिवेंट करने के लिए इन्होंने वैलिडिटी अफेक्ट नहीं करी. Prohibition of Child Marriage Act has changed the position. It has made child marriage voidable. Prohibition of Child Marriage Act has changed the position. It has made child marriage voidable. Okay, so again the child marriage is voidable. That means void plus able. And it has given rigorous imprisonment of 2 years or fine extending up to 1 lakh. So it has increased the seriousness of the situation, right? And see also the years in which these two acts were passed. So according to the circumstances prevailing in those years also the situation has changed, right? May be imposed in case of contravention of any of the provision, but even now child marriage is valid. Why valid? Because it is voidable. That means void plus able. So till it is dissolved or it goes into a court of law for setting aside, it is considered to be a valid marriage. Then Prohibition of Child Marriage Amendment Bill 2021 proposes to increase the marriageable age of girls also from 18 to 21 years. Okay, that means there will be an equality set up that both genders would have the same age for marriage, that is 21 years. Bill adds the provisions shall have an overriding effect over any other law, custom, usage or practice governing the parties to marriage. Overriding effect means it will override. Override का मतलब something riding, override मतलब इसके ऊपर चलना, right? Simple भाषा में that means this law will prevail over any other law custom which is governing those parties to the marriage. For suppose if a law prevalent at time today says that there should be 2 years fine, okay, for suppose a very layman example I'm giving you. So if the law at present says rigorous imprisonment of 2 years, but this amendment bill says that 5 years, so now you will be confused which one to follow, this one or this one, right? Because both the laws are prevailing now. ये बिल एक्ट बन गया, ठीक है, और अब प्रिवेलिंग मतलब फोर्स में आ गया. सो दिस इज ऑल्सो एन एग्जिस्टिंग लॉ, दिस इज ऑल्सो एन एग्जिस्टिंग लॉ. इन वन केस फॉर अ सिचुएशन prescribed imprisonment is 5 years, in the other one it is 2 years. So now there is a confusion which one to follow, right? So in that case, since it contains that provisions have overriding effect, that means this will prevail over any other law or customs. See, it has also taken into its ambit the customs and usages or practices which are going on or which are passed from generation to generation traditionally, उसको भी override कर दिया, ठीक, कि those customs will also not be obeyed and only the provisions of this act would prevail. That is the meaning of overriding effect. Okay, so here your chapter is completed. Thank you so much.